Good morning, everyone. We're going to go ahead and begin. I'd like to introduce myself. My name is Marcia Vial, and I come from the Pueblo of Acoma. I also work for my tribe, Pueblo of Acoma Social Services, and I do serve in the capacity of the Child Welfare Specialist. And I'd like to thank all of you for joining us again today. And we really enjoyed your company last night. And I appreciate the openness and the heartfelt way you were able to engage with us as tribal partners. And I'll pass it on to Cindy.
Good morning, Yat Bene. My name is Cindy Aragon. I'm with the Office of General Counsel, Assistant General Counsel with CYFD. My clans are Chenjikine, my maternal clan. My paternal clan is Nakai, born for Nakai. My Che, which is my maternal grandfather, is Tachitni, and my Nali, which is my paternal side, is Nakai. So that's usually how you introduce yourself in Navajo. I didn't do it as fluently as I should. So it would be Cindy Aragon Chia, Chenjikin and Shlen Nakai Bashachin, Shiche Tachitni Shinela Nakai. And that's how we as Native people in the Navajo identify ourselves, and we identify ourselves not just me as a person and my personal identity, but I have the identity of my ancestors from both my parents' side, my paternal and my maternal side. So I have 4 clans that I've listed, 2 from my maternal and 2 from my paternal. So there's always some sense of family, some sense of belonging, some sense of being with and interconnected with my community based on that. Good morning, and thank you for having us.
Good morning, everyone. My name is Julie Bird. I come from Okeawinge. I serve as the ICWA manager for Nambe Pueblo. My title there is ICWA manager. I reside in the community of Okeawinge. My children are also from Okeawinge, and I'm here with you all today to hopefully share some really helpful information on best interests and cultural compacts. I also wanted to recognize that Nambe Pueblo is a seated member of the New Mexico Tribal Indian Child Welfare Consortium, and we've been actively participating with the consortium since 2016. So welcome, everyone. As well, I did participate in some circles last night and with some of y'all, and I too want to also thank you for your open heart and open mind to really, truly, authentically, and genuinely engage with the style and way we communicate when it comes to learning about who we are and who we're about. So thank you so much for spending that time with us last night. And I'll turn it over to Cindy. Thank you.
Thank you, Julie. Thank you, Marcia. And I'm quite honored to be presenting with these 2 very knowledgeable women, very strong New Mexico TIC members and tribal community members. How I wanted to start this is in doing this presentation when we were asked to do this. One of the questions that came to mind is, what is best interests? And I had a hard time really coming up with a concrete, definite, specific identification or description of what that was. So if I asked you, and let's say I was the judge, and I asked you, what is best interest? What would you say? What would your response be? Anybody? Nobody? Intact family? Anyone else? It depends. Okay. Anyone else? A series of decisions that affect the child in the most positive way. So, individualized each family, and I missed the last part.
Before in court.
I'm sorry. Court case. So that still is very broad, right? All those definitions, all those ideas of what comes to mind when you're posed with the question of what is best interest are still very, very broad, right? So when I was thinking of this, the question came to mind of what is it? It's identified in our children's code throughout. It's all throughout our children's code. It's in our child abuse, in our neglect, our adoptions, the article on the mental health and juvenile justice. It's throughout our code. So when we look at best interest in the context of looking at it for Indian children, the foundation of where that came with ICWA, the Indian Family Protection Act, is a federal law that came about in 1978. And basically, their declaration of policy specifically identified generally best interests, the best interests of Indian children. And the best interest is to promote stability and security of Indian tribes and families by the establishment of minimum federal standards. So again, the security and stability of tribes. Again, that goes with sovereignty and the issue of tribes having the ability to establish those criteria for themselves. And then also looking at standards for the establishment of standards for the removal of Indian children from their families and the placement of such children in foster adoptive homes which reflect the unique values. So that says unique values, that's important to note, the unique values of Indian culture, and by providing for assistance to Indian tribes in operation of child and family programs. So it's very, very broad in a sense of what is in the best interest. And we know right now that we're awaiting a federal court decision on the Brackeen versus Holland case. So we don't know what's going to come down at the federal level, whether they're going to determine, if this is going to be ruled, if the whole portions of the Federal Indian Child Welfare Act are going to be ruled unconstitutional, and how they're going to determine that. So it's a very scary time for tribes right now, because a lot of tribes are very supportive of like what we call the gold standard in child welfare and operations of those. So one thing that comes to mind in making your decision as a judge or a person that's influential in the child welfare system. So when we did our exercise yesterday, the group that I had, what we did is we each had a piece of string and we wrapped it around our waist like if it was a hula hoop. And then as I asked each question, they ended up wrapping that string around somebody else. I said, wrap the string on the right hand of the person to your right. How many of you have a dog? Wrap the string around the person with the dog. And before you knew it, everybody was all tangled up in the different colored string. And as they sat there all tangled up, I said, this is what it feels like to be in a child welfare system for our children and our families. And so that comes to mind in looking at how we make decisions that will be in the best interests of our children, and being able to make those decisions in a way that's going to have an impact on the well-being of that child, not just short-term, but long-term. Not just now, here and now, but also long-term. So the questions that came to mind in looking at best interests and looking at the idea of where that comes from, how much of a objective versus subjective viewpoint do you think that plays? Do you think our personal opinions sometimes, our personal influence, our personal feelings sometimes play into that? Or is it all based on facts? Is it all based on what is before us? And how do we make those decisions based on that, so that we're making the best decision on behalf of that child? So as I searched through the language of best interest, I did have, like I said, a difficult time, because I figured it seems to be very fluid. It's not a concrete block that you can say, this is what it is, this is what happens here. So I searched best interest, and I found best interest in 3 places in the federal law. And this is one place that was found in regards to the return of custody. That a final decree of adoption, if it has been vacated or set aside, or the adopted parents voluntarily consent to their termination of parental rights to the child, a biological parent or a prior Indian custodian may petition for return of that for custody, and the court shall grant such petition unless there's a showing in a proceeding subject to the provisions of that title that such return is not in the child's best interest. So we talked about other things like Donna Lynn mentioned, bonding, attachment. When kids are placed with foster families, they bond and they attach. Kids that have an opportunity, that don't speak their language, and they have an opportunity to connect with their tribes, to be somewhere where they feel like they belong. It's important to consider what is the best interest of this Indian child. In looking at what you've learned so far, and I know this is just kind of an introduction for some of you, do you feel that the best interest for an Indian child is different than the best interest of a non-Indian child coming before you? Any comments, any thoughts? If you need time to just think about that. So it's important to note that the Indian Child Welfare Act was enacted at a time when Indian self-determination was when in history, after the assimilation era, after the reservation era, after all these things that passed, the treaty era, then the federal government said, okay, tribes, we're going to give you an opportunity to be self-governing. We're going to give you the chance to do Indian self-determination. This act was developed during that time in our history. You guys want to add anything? So in regards to our children's code, the children's code, the purpose of our children's code in state law says specifically, and I'm just taking one of those provisions because there's other provisions there, best interest is mentioned there in the general provisions of the purpose of our children's code. And it's a general, again, a very general statement, talking about a child victim and talking about enhanced coordinated responses of all agencies to achieve the best interests, a coordination and cooperation of civil and criminal systems that involve investigation, intervention, disposition of cases, and to minimize interagency conflict. So again, it's the foundation, it lays the foundation of why we have a children's code, and also why we also have an Indian Child Welfare Act. Okay, guys. So what we're going to go into next is the Indian Family Protection Act and the importance of the Indian Family Protection Act and how that came about. So I'm going to defer to both Julie and Marcia to talk about their involvement with that and why they felt it was so important from the best interest perspective.
You want to go first, Julie?
Nambe Pueblo, being actively an active seated member of NMTIC, we were having ongoing discussions of what it is as tribes we really needed to strongly advocate for our tribal children in the state system. And you know, the brainstorming of a state ICWA bill was a hot topic for us as a consortium. And it took a lot of work to really advocate not only for tribal children in New Mexico's system, but also there's an additional layer to that as a seated member representing the Pueblo of Nambe, and looking at the uniqueness and its own individual practices and customs that make it stand out amongst the other pueblos, and really being an active participant in the development of IFPA, and also vocalizing the importance of being considerate to our uniqueness as Nambe Pueblo and what we feel are really important points to consider in serving our children. You know, that's more or less the role Nambe Pueblo played in the development of IFPA. We carry a lot of lived experience in walking through cases, our ICWA cases, that fell in counties such as Torrance County, Valencia County, Bernalillo County, Rio Arriba County, Santa Fe County. And so out of those experiences of being an ICWA worker for the Pueblo and really looking at what was going on with our children in the state system, that is what we brought to the life of the Indian Family Protection Act. We shared those challenges. We shared those barriers. We shared suggestions and ideas of what it would look like to truly have a real and genuine partnership with our state partners when we're really looking out for the best interests of our children from Nambe, as well as our brothers and sisters from our tribal nations. And so IFPA, as eloquently stated by Donna Lynn in the earlier presentation, IFPA is a testimony of lived experiences. And it wasn't written coming from a place of somebody who doesn't know tribal communities. You're getting first-hand knowledge and experience in the law. That is the law here in New Mexico, and I don't think it gets any better than that, right? As far as how you guys embrace the Indian Family Protection Act. It's coming out of the mouths of the tribes, not from an attorney, not from somebody who may have written state ICWA bills for other states. This state stands out because it came out of the mouths of the tribes as to what wasn't working and how we can help make this work and still be respectful and honor the uniqueness of our sovereign nations when it comes to the well-being of their children. And so that is what drove me to show up to every meeting involving IFPA. That is what drove me to show up. At one point, we had a 12-hour marathon about talking about IFPA, and that included tribal leaders, and it was like, I gotta feed my kids, I gotta still do homework with them, I gotta be present with them. All the meanwhile, I'm on this 12-hour marathon trying to advocate and speak up, not only for our tribal children, but more specifically Nambe Pueblo and what's in their best interest involving their children. And so when it comes to best interests, I feel that best interests, like Cindy shared, is fluid throughout the life of the case. From investigations all the way to crossing our fingers, reunification. Because that is our ultimate goal with our families, right? Is to see that they're in a little bit of trouble, but hey, let's support them. Let's lift them up. Let's be there with them so that they can be the family that we hope them to be. And so I just wanted to share that. As far as best interests, I know she wants to go into fictive kin. For us, fictive kin in our tribal community is a very foreign term to us. Relative placement, we can hug that and hold it for a really long time, because that is something we've practiced generation upon generation. And the reason I can say that, and you have examples of that, you had Donna Lynn share her story of how her grandparents raised her. That's relative placement. And that's something that's been practiced in tribal communities for a very long time. So when it comes to the practice of fictive kin, trying to identify and define what fictive means to a tribal community, it's a very foreign term that we're really trying to tailor and modify to fit best for Nambe Pueblo. And so I just want to share that. I also want to share my mic with Marsha, because like y'all know, don't give Julie the mic. So I'm going to turn it over to Marsha and see if she has anything she'd like to share as well in regards to this. So thank you.
Well, actually, this is one time. Go ahead, Julie. You're doing good. And just with that, you know, the best interests of our children. And I'm going to go with what Julie was stating in regards to relative placement and what is the best interest. In our communities, as Donalyn stated, we are brothers, sisters, mother, father. It's all a cultural component and tradition growing up, and I'll share that with you because I'm a ground worker. I work directly with my families, and I love the work that I do. And when we speak about the best interest, I grew up with my grandparents. My mom never said, oh, I'll let your grandma adopt you. I think I just literally moved out of the house on my own because we love our grandparents, right? We know how good they are to us. Not only that, but in summer times, I would go back to my parents' home. It did not have no effect on me of, oh, you know, they abandoned me, or did I have those thoughts of that. That was never even crossed my mind. Lot of communities, that is how we interact with each others, and it's the cultural component of who we are. That's our existence of livelihood for us, our families, and our children. And it has been mentioned that the tribe is the third parent. Well, as a worker, I look at myself as the third parent. If a child is in my community and say they are doing something wrong, I may not have ever known that child, but I know the family they come from. You believe they will get corrected, because that's how we are as community. We look at every child as our very own. So being the third parent, when we're in these court systems and we come before you in your courts and you ask us what the best interest is having our children remain within their own communities, be in place with their own relatives. How we identify relatives is mom, dad, brother, sister, aunt, uncle. We don't define first cousin, second cousin, third cousin. That's foreign to us. I'll even share that as we live as community, Miss Bird has 2 children. They call me auntie. you know, she lives way up north, I live way, what direction? West, okay. Not all natives know their directions.
You just point like that.
Just follow my lips. That's a traditional thing, like the snack part that you were all, okay. So, you know, so that's what we mean by cultural connections, community, and looking at each other's, looking at our children. A lot of my consortium brothers and sisters as well, we identify their children as our children. It's innate in us. It's not even foreign to me. Even when I talk with other Native children that I see, I'll identify son, daughter. So as we're going into what it means, fictive kin, I just wanted to share that component with you. Just because I wanted to share my experiences of how I see our families and how I would hope that you would also see them when they step into your courtrooms and what the best interest will be for them. Okay, Cindy.
Thank you, Marcia. Thank you, Julie. And the definition of fictive kin was a definition that we worked with in the drafting of the Indian Family Protection Act to make sure that it was over-inclusive and that it included traditional, customary or traditional law, customary practices that are unwritten, that are going from generation to generation, oral practices, and that it was done that included godparents, because in the Pueblo culture, godparents are very important, and included extended family member, and also the relationship with the child existed prior to them entering into foster care. I know there was a lot of concern about foster parents being left out of this definition, and the definition did not include them because they developed the relationship with the child after the child was involved in foster care. But the ultimate purpose and the discussions that were underway in looking at expanding this definition and looking at it specific for the best interests of Indian children was to give tribes and extended family the opportunity to step into the shoes and to be there firsthand as a community, as a family. You guys want to add anything to that? No?
No. Okay. I think we.
So one of the things that comes to mind when I looked at this slide and when I was listening to Julie and Marcia talk is when we were conducting the implementation training within CYFD, and I was co-training with a number of individuals. Somebody asked me, well, what is culture? What is it? You know, how do you identify it? And we're going to address that piece of it later on in today's conversation. But I was like, it kind of threw me off guard because I was like, you don't know what that is? You know, and I was just like, you ask a Native person, they can automatically just list everything what that is. And so it was really odd for me to hear that. So to keep that in mind as we continue to move through the slides.
Can I just make a comment when I hear that, what is culture? And someone asks me, well, culture to me is I live it. It's my daily life. It's who I am. Every day I wake up and I look in that mirror. That's culture. That's me. That is how our children are. It's in them. And trying to explain it, like Cindy said, we may have some words for it, but culture for Native people is our livelihood. It's the mere existence of who we are and how we live and what we do, how we love, how we care, and how we share.
So, and again, after I Controlled F the Indian Family Protection Act, I came again with two other sections, another section on intervention that talked about best interests, and set in the provision C, in determining whether a person described in subsection B should be permitted to intervene, the court would consider the person's rationale for the proposed intervention and whether the intervention was in the best interest of the child. And when you look at B, the definition again was extended to include the Indian child's relative or extended family member, the guardian, the Indian custodian, or a foster parent. Again, the foster parent would be within whom the child had resided for at least 12 months. So we were hoping that in looking at, we understand that our foster parents and that the work they do is important, and we are grateful for that. By all means, we're not saying we're not grateful for that. They open their homes, they open up their arms, they bring these children in. But we also have an obligation pursuant to our code is to reunify our children with their families. And I think many times as state agency, as courts, as child welfare agencies, social workers, and people that deal in the child welfare realm, we tend to say, well, how come this child was returned to the family that beat him? Or why is this kid back with this family because they did this to him or her? You know, and I think there's just this sense of maybe maybe it's time that, you know, we educate also that we have an obligation to reunify first and look at family before we say, no, we're not going to ever send this kid back to you. And that's important to note, because I think a lot of times there's this misconception from our public that why are kids being returned to families that abuse them? Why are they returned to the same environment that they were taken from? And that's not what we're there for, is to, if it affects safety and well-being, yes, definitely, but not for other means that are important, like family ties, connections, and commitment to the community. So also our rules and our forms still haven't been updated. So I know a lot of our forms are still in the format that follow the Indian Child Welfare Act, the federal law. And so I just copied this one again because it talks about the best interests of the child. But most of our forms, I don't think we have had a forms committee working on those rules and forms yet, but I know that eventually will be coming to revise that, and I don't know what's going to happen with federal ICWA. So again, you know, that's still law. We still have federal law. We have state law. And so we have a combination of those two in looking at what we need to do and complying with the mandates of what the policy and the underlying best interests of ICWA is. So looking at voluntary placements agreements, this was a big one when we looked at best interests for Indian children. And one of the ideas that came to mind was, how can it be voluntary? How can a parent voluntarily place their kid within the custody of CYFD or a child welfare agency when they know that there's an ongoing investigation or something's being held over their head, saying you either do this or they're going to do any and everything to jump the hoops, jump the hurdles, do whatever they need to do to make sure that they pass the test to be able to get their kids back. So when they say voluntarily, when it was initially brought to mind, it was like, it's not voluntarily. When you have a pending investigation, when you have a pending court action or something pending, because it has to be, that's not voluntary. And the tribes really brought that forward in the drafting of this IFPA. So Julie and Marcia, you have any comments on that? So one of the things that came to mind in that, there was times when families, and I remember when I worked at Legal Aid, there was a family that had come to me and a grandmother, and she said, I want my grandson, I want to see him, I haven't seen him, it's been 2 years since he's been taken. I don't know where he's at. I have no idea, I miss him so much. And then she broke down crying. So after we checked it out and looked through and figured it out, the case had been closed. They never filed. The kid was placed with, dad was in prison, mom was homeless on the streets and using. And so this grandmother who had been raising this child was the one that initially called because she had concerns that her daughter was drinking and breastfeeding. And so she wasn't even given an opportunity to even know what was happening with this case. So that kid was taken, and from that moment on, from that moment that kid left that home, she never saw him again. So she came to us 2 years later and said, I don't know what happened to him. I don't know where he's at. So those were some of the stories, the testimonies that had come through in regards to why this needs to be voluntary. The placement within CYFD needs to be voluntary. There can't be nothing held over their head. And in normal sense, an extended family, if this was a tribal community, grandma would know. She would have a right to know what was going on, or she would have some way of being considered possibly as a placement. But they did. She was left out because she was not, according to them, appropriate. You guys, anything? Am I skipping?
In our court systems within ICWA, as Cindy had stated, the grandparents are welcome and to the hearings, and they do have a say in being a part of their grandchildren's lives. They're not ousted or told that they can't participate. So when we look at VPAs within our own tribal court systems, for our tribe, the consideration of all family members is usually appropriate within our settings. So just wanted to share that piece of how our tribal government for ICWA or our tribal court system works.
So also under qualified, do I have anything else to? Under qualified expert witness, under provision 32A 2817, the court shall consider whether it's in the best interest of the Indian child to remain in the department's custody for additional time. And that is 30 days after filing the petition, the department, if we have not identified a qualified expert to testify as required by the IFPA, and also the federal law, Indian Child Welfare Act, in considering a motion by the department for continuance. So in determining the best interests of an Indian child to remain in the department's custody for an additional time is, again, up to the court and based on a number of different factors. Do you have anything else? And the qualified expert witness, there's a special presentation on that this afternoon that will talk a little bit more detail about that qualified expert witness and the requirement for their testimony. And it's not just because I'm Navajo and I'm Native doesn't mean that I would meet the qualifications to testify on a kid from Nambe or a kid from a Assiniboine Sioux tribe or Fort Peck. Sometimes there's been that generalization of, oh, this person she's Native, she can testify, or this person meets the qualification because they're Native. And I think when we revise the definition of looking at the details of qualified expert witness, when you get to that section this afternoon, you'll see the changes in the language that specifically address that. One of the ideas that came to mind, you talk about culture and the different ways that people want to be enmeshed in culture. You hear about Sedona, you hear about teepees, you hear about people wanting to get a vacation rental by owner or Airbnb and stay in a teepee somewhere. Or you hear about the guy that was doing the sweats. And so some of the concern would be, can you have that person like from that was doing the sweats in Arizona come in and be the qualified expert witness? Is that going to be in the best interest of this child? Are you going to have someone that has no clue as to what's happening in this community testify about that? And it's important to note that because, for instance, like talking about sweats and the whole idea of, you know, sitting in a traditional sauna with the hot rocks, and Navajo women aren't allowed to be in sweats. We don't participate. So to assume that it's a one-size-fits-all is also something that we need to take note of and make sure that we're not doing that as we continue to address the cases that we deal with.
So really quickly, I'd like to share with you, when looking at qualified expert interests and also looking at it in a sense of coming from a best interest perspective. For instance, Nambe Pueblo, we're so small, I won't say short staffed because I'm short in stature, but we are more or less a one-person program for Nambe Pueblo. And so our goal is to work hand in hand with our state partner in identifying a qualified expert witness who is going to honor and respect and recognize the importance of the way we view child rearing practices in accordance to our tribal community. And so that is our goal in working in partnership, because if we can identify that type of person to come in and provide testimony in court, that is in a way looking out for the best interests of our children. And I always file a motion to intervene, whether it's on the, verbally or written writing. But I also explain that if at some point we need these QEWs at particular pieces of this case, I, as a Nambe ICWA manager, cannot serve as a qualified expert witness on my own case. And so that's been something I've really tried to provide my state partners with as, just food for thought. Like, here, I'm going to share this with you because, I can't give testimony on your case, because if in the event the tribe needed to question your expert witness, I can't question myself on the stand. And so, building that partnership with your tribal representatives on ICWA cases, or seeing that that's being shared, as you all judges sit and review the paperwork and the reports coming in, it's important, to know that tribes, when they do partner up with our state partners, are looking out and trying to practice best interests of their children by really working hand in hand in identifying qualified expert witnesses who can speak to the true practices of tribal communities and how they view those child rearing practices with our children. So I just wanted to share that. Thank you. Thank you.
I'm having problems with this little thing here. I don't even use my remote control at my house to watch TV. So if I'm switching back and forth, I'm sorry about that. I'm technically challenged when it comes to those things. And the important thing about looking at dispositional orders and continuation of dispositional orders and notice of permanency and permanency review hearings, the notice requirements are required for the tribe, and the department shall submit progress reports that documents best interests, that we have proposed treatment plan that serves the child's best interests. And so it's important to note that. And I thought of leaving out the 2, 3, 4, 5, and 6, and I thought, you know what? But best interest, in a sense of looking at that first provision, number 1, it also includes the importance of 2, 3, 4, 5, and 6. And so although it doesn't say specifically best interest here, best interest here, best interest here, I think it summarizes a little bit of what is important in identifying some of those important things that need to be considered in best interests. Okay. So the return of custody, this pretty much comes directly from the federal law, in the sense of looking at the severed adoptive relationship between the adoptive parents and the adoptive child, and that the biological parent, guardian, or prior Indian custodian may petition for return of custody. And so then there would be a presumption that the Indian child shall be returned. And again, it's unless the return of custody is not in the best interest of the Indian child. Anything on this?
No, thank you.
No. So when making determinations regarding best interests pursuant to IFPA, the court, after allowing testimony, shall consider the following factors. And this is a really, really important slide, because it talks about generally those areas about placement prioritization, according to placement preferences, the prevention of unnecessary out-of-home placements of the Indian child, the importance of the child establishing, developing, or maintaining political, cultural, social, and spiritual relationship with the tribe and community and family, and the importance of the child and the ability of the tribe to maintain its existence and integrity and promotion of stability and security, and utmost the important safety and well-being of the Indian child. So when you're looking at those factors and looking at these different things, it's important to note. So for instance, number C, this child has never had an opportunity to participate in cultural activities and cultural and traditional events. This child is what us Indians would call an urban Indian, maybe, because he or she lives in a metropolitan area, maybe Albuquerque or Las Cruces. So if this child hasn't had that opportunity, how can you say that you are giving this child the best interest if that child has never participated in cultural events? If you make a decision and says, well, he's never participated, he or she's never been involved, the family don't believe in that stuff. They say that they're Christians and they don't believe in the traditional practices of traditional ceremony. Would that be acting in the best interest of that child? If you said, no, I'm not gonna, this child has no cultural contact, so this is an area where I don't have to really address this. So when I looked at that, I said, well, the critical importance of establishing, developing, or maintaining. So it's not just maintaining, it's developing and establishing. And that's really, really important to note, that you may have a newborn child that hasn't had any contact, but yet that child is so sacred. That child is so sacred to the family with the name, as that child develops through different growth developmentally, spiritually, mentally, emotionally, physically, that they start developing and learning those cultural practices. It's not just like, let's go to the doctor, get you're 3 years old, let's get your shots. It's time to go to the dentist. You're 6. It's nothing like that. It happens based on the developmental progress of that child. Comments?
So I think in this particular section, I have encountered working with some of my state folks who have really had a difficult time digesting what we're sharing, in a sense of this child needs to continue to stay connected to their tribe, and this is our child. So the reason I say our child, and the state worker will combat that statement by saying, well, the grandma never lived here, the mom never lived here, nobody ever participated in ceremonies or activities here in the tribe. So I'm not understanding what you mean by this is your child when the child never even grew up here, nor did their mom or their grandparent. And, the best way I could try to bring some understanding to that argument is the child doesn't have to participate or be involved in any particular activity nor live in our tribal community to be connected to the tribe. At birth is the connection. Irregardless, at birth is how they are already connected to the tribe. And so when we're talking about sharing ways and ideas of looking out for our child's best interest, when we're developing case plans, when we're developing supportive services, how do you not consider that connection with their tribe and how to support that to help him thrive? And is it based off of just your interpretation of seeing this child not have a connection to the tribe, so we're not going to be inclusive of the tribe in our case planning? Because whether you believe that way or not, the tribe is already automatically connected to this child, and this child is connected to the tribe at birth. That's the understanding that I try to share in order to help my state partners get to a place where we can work together, right, to support our family and succeed in reunification. And that's been one of the more constant conversations I've had to have with some of my state partners, is helping them to really grasp that perspective of how we view our children. And when we're able to fully digest it, it makes for a really great outcome with our state folks, because they get it. They get why we're at the table as tribal reps, really truly advocating for the best interests of our children. And that is sort of the experience I've had in regards to always being mindful of our kiddos and their best interest. So with that, I'm going to turn it over to Marsha if she has something she'd like to share. Thank you.
So I'm going to go into the letter E, the protection, safety, and well-being of the Indian child. So I'd like to share in my experiences of our tribe, ICWA. We do license our own homes, and prior to us having the ability to license, we've had state agencies come and do a home assessment. And because we're a traditional family, we live on a mesa top, we have no running water or electricity. A lot of our traditional homes still have some dirt floors on there. So those considerations of a dirt floor to an outside agency meant that it was dirty, that it wasn't kept clean, that the child can't be in this type of environment. Where's the child's room? It may be one local area that you may have several family units that are a part of that home. So each child will not have their own home. And when I think about this in my childhood growing up, it's kind of ironic because my relatives, my brothers and sisters, when we'd be and gather at the traditional home, it be about who got the best part or the coolest part of the floor, and we throw down our blankets and we be fighting for that area because that's where we're gonna sleep that night. It wasn't unusual not to have your own room. If you had your own room, hey, you're in luxury, man. But, you know, just sharing these kinds of experiences of how we live and how our safety being or lying on the dirt floor is not a form of neglect or abuse. So these are some of the things early on that as a worker I experienced with the state agencies and how they looked at our homes. Another example is we have a lot of traditional regalia that may be hanging on the walls. So you may have objects that have sharp ends. Those were also taken as a danger to the child when it may have some significance in a ceremonial that was considered, you know, while the child could take it and cut themselves or harm others, while that child knows at an early age the sacredness of that object. So in Native homes, that would not be an issue or concern. So just wanted to share in that aspect some of the early interactions that we've had with others in our safety of our children and well-being, that we are capable of taking care of them, and that some of the observations that were made were from a lens that they did not know our traditions and culture, but we did not harm our children, or our children weren't harmed in those circumstances.
So also the importance of a best interest is that there's always the appointment of a guardian ad litem who makes the decisions on behalf of a child under the age of 14, and then if they're 14 or older, they will usually appoint an attorney. So looking at, gosh, there we go. Now we're into what is culture? So when you see this picture, which is a famous picture by a Native American photographer, Lee Marmon, titled "The White Man's Moccasins," what comes to mind based on what we've presented so far? Anybody willing to share?
There's microphones in the middle, or if you can yell out your answer.
I feel like we're in our first group.
And remember, we're all here to learn, so any answer is not going to be looked at in any way, shape, or form. So if you're brave, I encourage you to take a shot at what that means and what Cindy has asked.
Traditional jewelry, okay. Looks very happy. Happy and content, huh? Modern footwear, Converse, which are the white man's moccasins. My grandpa used to wear Converse. So when you identify culture, it's important to note that what is it and how it differs for each individual. It's not a one-size-fits-all, and it's unique to that individual person, to that individual child. And one of the things that I liked about this photo is I think it's very powerful in the sense that it talks about the differences of almost two worlds. The Western European world, with maybe that's his cigarette or his cigar, or his traditional tobacco. And then you have the modern dress with the shirt and the pants and the tennis shoes. But you also have the traditional, the headdress, the jewelry, and and being content with where he's at at his homeland. So cultural compacts is the next area that we're going into, and that's an agreement that documents how an Indian child that's being adopted or placed in a guardianship home will continue to be able to actively participate in the child's cultural learning and activities. And this is an agreement between the tribe and the adoptive parents or guardians of the Indian child who are not members of the Indian child's tribe.
So one thing as a tribe who actively practices cultural compacts, even though it is written in the law that it's only at the place of adoption and guardianship, I really want to open everyone's minds to really grasping that the compact in itself, yes, is a key component to the well-being of our tribal children at that stage of a child welfare case. But in all reality, the compact opens up a lot of doors between the tribe and the family to have ongoing discussions about what that connection truly looks like, all the way at the stage of investigation. Because it's about that connection, it's about recognizing and acknowledging that there's a connection, because sometimes our families don't feel connected to their tribe. This is the opportunity to have those discussions if you're truly trying to capture the best interests of the tribal child or of the tribal children. And then also, as it was shared earlier, the tribe itself is a parent to the child. So there's another piece that also plays into the importance of the cultural compact. Usually how I try to share discussion about cultural compacts is I try to say, your interpretation, your definition of compact, let's take that definition and let's put it on the shelf for a moment. Because the spirit of the compact itself has to do with having that dialogue and discussion between the tribe and the family, period. And it should only be between the tribe and the family and the children. And so who knows better in how to lay a really great foundation of support for a child to stay connected to their tribe than the tribe itself. They are the experts on how to raise their children, and these compacts reflect that. But I run into situations where sometimes a guardian ad litem may want to become involved, attorney for one of the parties, and it's really a challenging encounter to explain and express in a way to where all parties can comprehend that it's an intimate conversation, not for the ears of anybody else other than the tribe and the child and the caregivers of that child. So I really want to share that with y'all, because I think that even though in the law we see it at the place of adoption or guardianship, it truly is actually a conversation that should be starting right at investigations. And as state partners, we're hoping that you have that way of supporting us in the way we're connecting with our tribe, with the tribe and the child. And so I just wanted to share that. I also, and I apologize, I was a very huge, loud voice in this particular piece of the law because I shared with my enacted brothers and sisters a situation I walked through. I came into Nambe Pueblo, and in my first 3 months of employment, I had a young person come to me who was adopted out by a non-native, non-relative, and came to me and asked me, "Can you help me visit my siblings because I haven't seen them in over a year, and I was promised that I would get monthly visits with them." So as I requested some information from him and his adopted mom, and I talked to our tribal leadership and asked for information about this young person and anything they could provide me to help me support his request, I came to find very little, if anything at all. And when I did review the documents his adopted mom provided me, there was nothing in the decree that mentioned sibling visits monthly. Nothing. And then when I spoke with our tribal enrollment to try to identify the siblings and try to connect with them, Nambe Pueblo has no way of knowing where they are or where they're at or how they're doing because the adoption, when it was finalized, disconnected the tribe from these children. So to this day, I still have no way of, and I get kind of I shared with my enacted brothers and sisters the look in that young man's eyes when he came back to ask me how we were going to connect him to his siblings. It was the most impactful thing on my heart and my spirit to have to tell this young man, the tribe has no idea where these children are, where they're at, and how to help you. And even though you were promised to have visits every month with your younger siblings, we don't have no way of holding that and into a place of, where the law says we have to do this, because it was never put into the adoption decree. And those children, I don't know where they're at. I don't know where they're at. And that stayed with me. I've been with Nambe Pueblo 5 years now, and that stayed with me as I continued to sit at the table when the drafting of ICWA and then eventually IFPA came to be. That look on that young man's face stays in my mind, because I think, what if that is my child looking to stay connected with their brothers and sisters? And what is that child walking through now? Because they have to be told, there's no way we can help you connect to your siblings. And for us at Nambe Pueblo, that is the reason we spoke up and wanted to make sure that we are recognized as wanting and willing and advocating for the connection of our children with tribe and tribe with children. And we want that support. We want that support. And that is why we shared our importance and our ways of expressing the importance of a cultural compact. And at Nambe, we don't talk just to the place of adoption or guardianship, then we bring up compacts. And those in practice with me, my state partners who've practiced with me at Nambe Pueblo with our children, they know the word cultural compact because it's a very mentioned thing within the duration of the case on across the board, from the clinical folks to the guardians to the casas to the attorneys, even to the judges. And so I just wanted to really share that story with you in hopes that you all will honor those compacts if they should come to be at particular stages of your child welfare cases you see. So thank you though, but I'll turn it over to Marcia and Cindy. Thank you.
Well, I'll go ahead and speak to cultural compact that did involve 4 tribes. And the finalization of the adoption was in February in the Farmington area. And actually, Judge Sarah Weaver is she here? Okay. Hi, Sarah. I'd like to recognize her because she was the one who, our child, that had affiliation, that has affiliation with 4 tribes, that we were able to put a cultural compact where 4 tribal sovereign nations embrace this child as their own, and this child will be connected on not just one level, but on 4 levels throughout their lifetime. So, yes, thank you. So it was a lot of work. You know, we have to get with all the other tribes, all the nations, but the one thing or the one goal that it has is that this child can go to any of these tribes and has family, and this child is going to be embraced and loved no matter how old she's gonna be. She's gonna have that family connection. And when we first got the notice of this moving forward, the excitement of doing the family chart was really exciting, exhilarating, exhausting, like all your emotions flood at one time because cultural compacts are new. But yet, in a sense, in Native country, we've been doing this with our children across the board. We didn't have a piece of paper to say you're gonna keep those connections, but because it's on a legal aspect of it, I ask that when these compacts do come before or into your courtrooms, that you do engage in what they are stated in them. Those connections will be maintained with siblings, with grandmas, grandpas, everyone. Not only that, but they have cultural feast days that they can attend throughout the year. And so that is my experience. That just happened recently, so it's a great accomplishment for a lot of our families that are going to be moving forward. And as Julie had brought, that it shouldn't just begin at the adoption stage, but throughout, because we had that question or the statements, because I've heard that too in several of my cases. Well, they never lived on the tribe, they don't know their culture. Well, guess what? This is a great opportunity. I'm glad you said that, because let's go engage them. Let's get them connected, you know. So just to keep that in mind. Thank you.
And just one other point, it's not a form that you fill out. That it's not the standard agreement in a sense, hey, I'm going to pull up a standard agreement and have all the provisions of an agreement. It's developed specific to that child by that tribe. So it's not a one-size-fits-all. So if you're asking for a form to fill out or what one looks like, they're unique to each particular child, the Nambe one, the ones that Marcia did, and they're not developed by a form. But the tribe has worked so hard to that. We had a case with CYFD where the older child was aging out of CYFD, the younger child was being adopted. And the tribe wanted to enter a cultural compact with the adoptive parents of the younger child and wanted CYFD to do a cultural compact for the older child. And we said, this is not what the purpose of the cultural compact is. We as CYFD will do a transition plan that identifies specifically how we will make sure this child has cultural connections, the one that's aging out. But we will not be a party to the contract, to the cultural compact. That's between the tribe and the adoptive parents. So that ends our presentation. And I want you to just keep in mind, I did ask that question, what is culture? And that person that asked me that, and I thought to myself, well, what is it? And one of the things that's important to note that many times Native families are connected to their homeland, where they were raised, where generation after generation, families were raised. They were raised in communal settings. They were raised in where they looked out for each other. They were related to everybody. You could say, these are all my clan members, and you'd have a whole house full of people. In fact, at my Navajo wedding, my husband, who's non-Indian, he said I had 4 people sitting on my side and the rest were all her clan members. So it's the families are there and we have that connection. So we always go back. You know, in Western European societies, our families, our parents sell their home, grandparents sell the farm, people move away based on where they live. Going back to where you grow up, you don't usually see your friends that you grew up with, that you played with down the street. In our Native communities, it still remains there for us as Native people. And sometimes I thought of that and I explained that to my colleague and she had a better understanding. But sometimes we take a lot of that for granted, and I just ask that you consider the best interests of a child long term in making the decisions that you make. Thank you. I'm gonna say.
Tawa
Kun awoha.
Yeah. We do have a couple minutes for questions, 3-4 minutes. If anyone has any questions, comments, or if you feel like you want to approach us individually, we're open for that as well.
Father and a non-native parent on the other side. I had that case in front of me last year, and I did some things to try to protect those cultural connections, but I don't even know that I had the ability to do that at the time. So I would just like to talk about that a little bit.
Did everyone hear the question? How would you apply some of these cultural, cross-cultural connections in regards to family law cases involving divorce between parents when you have a non-Indian parent and an Indian parent, and you have non-Indian families and Indian families?
Well, I would suggest probably reaching out, finding the tribe, and reaching out to that worker and seeing if that worker can help connect the relatives to the individual, because they would be the one to make those cultural connections, especially if it's not in a state case where we're talking. It sounds like it's on the civil side, and that connections want to be maintained. That would be my suggestion, to help or have them reach out to the tribe and see how they can make those connections on the family side to ensure that their family member stays connected. That's what comes to my mind, but I'll leave it open to Julie and Cindy.
So what comes to my mind as an attorney practicing in domestic relations cases as well, I think it's important to be cognizant of possible cultural differences and how culture and the differences are viewed by the other. So for instance, a Western European non-Indian culture may view some practice of native culture as very archaic, very, and how that could be used as an impediment to get the kid to be with mom and say mom's native. Because mom's living with her parents and they live on ICWA Pueblo, they have dirt floors, and that's not in the best interest of this child. But when it comes to safety, well-being, and the best interests of that child, that's part of that child's culture. And to be cognizant of not alienating that child from the opportunity to experience both cultures and not using one as a dominating culture over the other.
But we can have some conversation. And I appreciate you sharing that question, because even though, child welfare cases loom around, abuse or neglect, we do also want to be supportive of our tribal children that fall into those circumstances, right? Where it's about a divorce and a separation, and maybe getting creative on how to be supportive of your question and really brainstorm on how to support and encourage that connection, right? And at least I think even the importance of acknowledging, because I learned this from Judge Romero, as judges, you all set the tone in your courtroom, right? And I think that when a judge is acknowledging the cultural component in any way, shape, or form, it's setting the tone for all parties to be able to hear and embrace. So, I would love to pick your brain, sir. But thank you.